Estrada versus Desierto. GR number 146710-15, March 2, 2001. Facts. After the people's clamor in EDSA for him to resign from his position, Petitioner Joseph Estrada issued a statement that he will be leaving the Malacanang Palace in order to have a peaceful transition of power and start the healing of the nation warped by confusion due to his impeachment trial. Nevertheless, he sent a letter to the Senate President and the Speaker of the House stating that he is temporarily unable to perform the duties of the office of the President and let then Vice President Respondent Gloria Macapagal Arroyo assume the position of acting President. Later, the Office of the Ombudsman filed plunder and perjury cases against the petitioner. A special panel for prosecutors were assigned to investigate the charges against the petitioner. Thus, the petitioner filed a petition for prohibition before the Supreme Court. He alleged that he cannot be criminally charged by the Ombudsman on the ground of immunity from suit. He claimed that he is still the President of the Philippines and that respondent is merely holding the position in an acting capacity. Further, he claimed that he cannot be considered as to have resigned because he is prohibited by law from resigning since he was under an investigation, which was the impeachment trial. Issues. Number 1. Whether or not the petitioner resigned as president. Ruling for issue number 1. Yes, the Supreme Court ruled that in a resignation, there must be an intent to resign, and that intent must be coupled by acts of relinquishment. The validity of a resignation is not governed by any formal requirement as to form, since it can be oral or written, expressed or implied. So long as the resignation is clear, the same must be given legal effect. In the present case, it was established that the petitioner resigned from his position as President of the Philippines. According to the Angara Diary, which serialized the final days of the petitioner in Malacanang Palace, the petitioner made pronouncements which was interpreted as intention of giving up the position, such as when he proposed a snap election where he should not be a candidate. Non-defiance to the request of a peaceful and orderly transfer of power, prior agreement to the transfer of power with conditions as to the state of petitioner and his family, and the issuance of a statement wherein the petitioner leaves the palace, the seat of the presidency, for the sake of peace and order. Hence, the resignation of the petitioner was implied by his actions to leave the presidency. Issue number 2. Whether or not the petitioner was temporarily incapable of exercising the presidency. Held. No. The court ruled that it is not within its jurisdiction to review whether the petitioner was temporarily incapable of exercising the presidency for being political in nature and addressed solely to the Congress as provided in the Constitution. Even if the petitioner can prove that he did not resign, the petitioner cannot successfully claim that he was merely on leave because Congress recognized the respondent as the de jure president, which cannot be reviewed by the court without violating the principle of separation of powers. In the present case, both houses of Congress recognized the respondent as the president when they issued resolutions to the said effect. Further, both houses issued a resolution approving the selection and appointment of Senator Teofisto Gengona as vice president. Further, finally, both houses started sending bills to be signed in law by the respondent. Hence, the petitioner was not temporarily incapable to exercise the presidency because he resigned as president, and houses of Congress already recognized the legitimacy of the respondent. Issue number 3. Whether or not the petitioner is immune from suit, and if so, up to what extent. Held. No. The court held that presidential immunity was granted only during the term of the president in order to prevent delay in actions on important matters by the chief executive due to litigations that may be lodged against him. The said immunity does not apply beyond the term of the president. In the present case, the petitioner cannot claim that he cannot be sued before the Ombudsman because he was immune from suit. In fact, the petitioner cannot cite any decision that the President has post-tenure immunity from liability. Further, the petitioner cannot claim that he is immune from suit because he was not convicted by the impeachment court. To allow such situation is to put a perpetual bar against his prosecution, which were criminal in nature. Hence, the petitioner is not immune from suit. Dispositive portion, the petitions are dismissed.